outstanding, but I would, with colleagues' approval, I would suggest that we take them as a significant line item at the next meeting, because I know the minutes for the immediately past meeting are not yet ready. So perhaps we could clear up that administrative matter at the next sitting. It's my intention to go straight into the matrix. I believe we were at page 14. Is it section 11? Is that correct, Ms. McCarthy?
Well, it wouldn't be page 14 anymore, sir. It would be that's at page 15 in this instance.
Okay. What section? Section
11, yes.
So that's part 4, designation of an authorized officer, correct? So make sure.
Sir. Yes, Senator.
Okay, I recall only, well, from what I see in the grid, we have one recommendation from the JDF. CTD Richards. What's the position on that? From a policy standpoint, is there objection thing on the policy side? And then I'll take colleagues' comments.
Chair, which page of the matrix are we? Chair.
We are, as told by Ms. McCarthy, this is page, I think it depends on how you've printed it or how you're looking at it, but we are at section 11, designation of an authorized officer, which is, for me, and the way I've printed page 14, but page 15 for some persons. So it is...
So Senator Lambert, there is a recommendation which says that the Commissioner of Police and the Chief of Defense staff should determine the method by which the collective and individual identity of each member of the task force may be ascertained. That's where we are at now. I personally have no difficulty with that.
I don't have a difficulty with it either, admittedly. Is this something that should the method be determined in the regulations and actually documented and not left to be inconsistent across different zones? I think if it's not detailed, you could.
I thought there was, might be the technical team can guide us, because I thought there was a standard way in which you identify the officers by virtue of like a badge number, and there were already some things in place. But it never hurts to have it in the regulations for clarity, Minister.
I think the identification, or how I read it, and I'm not there from a technical team, it's not so much around the identification, it's really more the selection. That's, unless I'm mistaken. CT Richards.
Oh, in that case, I was certainly reading it wrong.
Because if we go back to the original,
let me look at it.
The original clause speaks to. No, I'm incorrect. I'm incorrect. CT. I must not. It's your original reading was correct. I think I'm incorrect.
My understanding, Chair, is that they are already identified.
Agreed.
Separate from the regular force. I believe there's a flag or a badge or some.
There's a badge and the vehicles are identified with branding as well, separate.
Yeah, so that somebody can know that this is a ZOSO personnel as against a regular member of the force, because while they're all constabulary force or JDF members, there is a difference.
Yeah, they become the members of the joint force.
Yeah. With the so that there's that. And what I understand you're saying, and I don't know, Senator Scott Markley, that it is the JDF, the Chief of Staff of the Compal, who will determine what the badges are, whatever. And that's so, I wouldn't have any problem either.
Right. And that was the point I was making, Senator Brown, that there would already be a designation. Although if the technical team suggests that it be put in the regulations, I would have no problem with that. But I think that what I'm doing is agreeing that the clause as it is should stand.
I agree that, you mean the section, Senator Motley? Section 11.
Yes,
as it
the
is.
one that we are looking at, section 11.
Should remain as is.
Yes.
I agree with that it should remain, that the Security Council should sign off on what badge of identification should be used. Basically, that's what it's saying, right? They use a badge.
They do.
Yes. They usually have a badge.
The uniform that says that they are part of the joint force within a zone. And that is the identifying mark that they use currently. And that identifying mark is one which is based on section 11 as it is approved by the National Security Council.
Yeah,
so that's why you read
the reason for change either, Senator Sinclair. I see SG trying to come.
Queen's Council Minister, Queen's Council SG.
For the record, let's also acknowledge and congratulate SG. Congrats.
Thank you. Thank you, Senator Scott Motley. But thank you, Chair. Thank you, Chair. Thank you, committee members, colleagues. Just to say that it was my understanding that I don't think the change was to remove the approval of the National Security Council. I think the issue was that right now it's the Joint Command that determines the method. And the proposal is not that the Joint Command make that proposal, but that it should be the Chief of Defense Staff and the Commissioner that would make the proposal and then have it approved by the NSC. Because I think what they're saying is, even though the Joint Command, they are senior members of both JDF and JCF, it really, something about determining the method of identity should really be the responsibility of the heads. And then those heads would then seek the approval of the NSC. That was my understanding of the proposal.
Yes, and that is what I understand also, except to say that throughout the bill, we have been removing the Joint Command and specifying, substituting instead the Commissioner of Police and the Chief of Defense Staff.
Okay.
That is part of what we have been doing consistently.
I agree with that, as the SG has explained it. I agree with that provision. Being amended, specifically referred to.
Sorry, Charlie, I agree.
And sorry, Chair, if you'll just permit me one other comment, even though I am not a member of the security forces, I don't think it would be a good idea to prescribe the actual method, because you see, methods can evolve and change from time to time. So the method right now could be the badge and how the badge looks, what the badge has on it, whether it's a number or other sort of designation. Over time, that method, they may need to change it for whatever reason, and they may need to do it very quickly. Prescribing the method could delay them, and you don't really want that to happen when you're dealing with what could possibly be a security issue. That would be my take on it.
Agreed to SG.
Thank you for the clarity to the discussion, SG. I think so. So is it fair to say we are accepting the recommendation here from the JDF? I think that's what I'm hearing from members.
Yes, Chair. To the extent that it changes Joint Command to the Defense Chief and the Commissioner of Police. I think that's the only change being requested.
Yes.
Agreed.
Yes.
Okay, so we can accept that one and move to section 12. Powers of the Joint Force. We had two recommendations, one from the JDF and one from the the JSF, both looking at section 12.1. Separate recommendations. I guess let's take the one from the JDF first, and we can then deliberate on the one from the JSF. The having a form established in the schedule. Oh, sorry, too. Recommended that. The only thing, and to SG's earlier point, is this something that we want to bind the security forces to? They may be tying their own hands.
Well, I don't know if it is about tying hands, Mr. Chairman. What I find arising in communities when special circumstances are established. So for example, a cordon or a curfew is established in a community. The area that is being affected and the way that the information may pass is where I believe most persons within a community also they would have a concern. And I don't know, I'm interpreting the recommendation from the JDF, because they're asking for something to be placed in a schedule as I read it, and the form of declaration and possibly the way that it is communicated to the community, because you are now going to be placing additional restrictions on a community. And what I find from community members is that they tend not to be aware of the boundaries that may be impacted by a curfew, as well as the fact that there is in fact a curfew taking place. And so you may have situations where disputes may arise between the law enforcement and a resident of a particular community or a particular area within a community that is being curfewed or cordoned. And I believe what they want to ensure is that when one is declared, that the boundaries and the time of the cordon and curfew is clearly established and defined, so that there is no dispute that may arise. And I suspect it is useful having regard to the fact that I believe there is a recommendation that there should be an offense if you breach the cordon or you breach the curfew conditions that are imposed. So I believe they're asking for a specific form by which it is declared, outlined, boundaries defined, time for the curfew and cordon. I don't know if my reading of what is contained in the matrix is exactly as they have expressed it. And
Chairman, it appears to me that again this is a similar problem of joint command.
Sorry, Senator Brown.
Yes, sorry.
You're getting you have on something that probably a fan that is distorting your voice, so I'm not hearing you when you speak.
My voice was naturally distorted, but all right, let me see if I can help. Issue 12.1 seems to be the redefinition of the giant command. So where it says in 12.1, subject to subsection 2, giant command may do either or both of the following. And they're saying that the Commissioner of Police and the Chief of Defense Force. Isn't that really where they're going, to make it consistent And wherever joint command appears in the document, it may very well be that they're saying just replace it. And I think we've agreed on that with Chief of Staff and the Commissioner of Police. The issue of the schedule, I'm not prepared to comment on that right now. I just want to ask, does a curfew have to be signed off by the minister? Or are we saying that this is now delegated to, if normally, that's not a curfew have the blessing of the minister. Is this changing that?
But when I look at the original act, Senator Brown, I see where it is a joint command who will establish a cordon or impose the curfew. So that is a power which they already have. What I'm seeing in the recommended change is that the recommendation is to say specifically that there should, the person so empowered should not be below the rank of Assistant Commissioner of Police, a Lieutenant Colonel, to establish a curfew. Here, as it is, it says that any member of the joint force may, for the purpose of enforcing such action, exercise such powers are vested in a constable. I think what they're trying to introduce in the section which you are discussing, the recommendation which you are discussing, is to bring in a sense of clarity about who can take such action. And they are saying it cannot be anybody below these ranks. And I think that it lends to more stricture and a greater amount of accountability, because it obviously is now left to the hierarchy. And before the SG comes on, I also want to say that the form of declaration would assist in some of the problems which we have been told that arise from time to time, so that there's certain knowledge about the cordon or curfew, and it is for each one, it is in the same kind of format. So again, it seems to me as though they're trying to regularize what is done in the zone.
I think I agree with you that the common thread between both recommendations, Senator Scott Motley, is the need for regularity and clarity to how it is declared and who does it. But I do agree with the recommendation that a curfew, which is, is a serious security intervention, really shouldn't be declared by anyone below these ranks. SG, your hand is up.
Yes, thank you. Thank you, Chair. I just wanted to, so I have no difficulty with what Senator Scott Motley has said and what you have also summarized, Chair. But just to give a little context and to perhaps try to clarify something that Senator Brown raised, under the Constabulary Force Act, the minister approves the curfew, not the cordon, but the curfew. Now, this provision in ZOSO was modeled to a certain extent from what's in Part 2A of the Constabulary Force, which gave special powers. This is a heading, special powers for preventing or detecting crime. But in the ZOSO Act, it didn't give the minister a role. So there is a difference between what's in the Constabulary Force Act and what's in the ZOSO Act. So I think, Senator Brown, that's perhaps what you were referring to. So I think when to comment specifically now on the JDF's recommendation, I don't know that you would necessarily need a schedule to the act. I mean, I would leave that to the CPC to determine, if the committee agrees, how that amendment would be done. It could be, though, just that whoever is going to establish either the cordon or impose the curfew, that it be done perhaps by way of a notice, and that notice is, posted somewhere. So we have different examples in different laws. Sometimes you post it at a public building, like a post office or a police station or schools, or there are different mechanisms to post notices so that persons in the affected community can become aware. But I I agree with a provision like that to make it clear that persons would know what the boundaries are, where they are, when they are, rather than having to walk up and see a barricade and then be informed by someone right there in the street in front of you.
I agree with you, but I think that they wanted to have almost like something that you fill in. That was the impression I got from the recommendation.
Okay, so you mean that the form should actually be in the act rather than, there are other times
that's
we
the impression.
about, okay, because there are times when we will say that there is a notice, but the notice is not actually always in the law. But, and again, then I wouldn't have any difficulty with that approach.
Well, I'm just following the schedule. Yes, I'm just following from how they have worded the recommendation, because they want to outline the form of declaration.
Okay, yes, okay.
And admittedly, I believe they should. To be, I mean, I'm not sure if that's the view of all committee members, but that's certainly my view. I see Mr. Grant trying to come in.
Yes, thank you, Chair. I just wanted to comment that if it's agreed that there should be a standard form for the declaration, then it could be conveniently done by prescribing a notice rather than having a schedule to do this.
Yes,
but the other thing to be considered, though, is what would be the effect or what is the time period for the publication of this notice? Is it supposed to take effect within or to be published within a certain time after the declaration is made or before? And then what would be the effect of a failure to publish? So those things would have to be clarified in the law. So you don't have, for example, a situation where by some oversight, the notice is not published and the validity of the declaration is called into question.
I think
how my understanding, and you know, I may be corrected since I don't have any familiarity with how the security forces function, but sometimes you have, if you're doing a curfew or a cordon, you might have to do so very quickly. So that we would have to determine, and I think we should get some advice on it, at what stage it is that we would post this notice. This notice should be posted. But part of what makes it attractive to me is that I think the citizens should always be aware of the curfew or cordon in the earliest possible time. It's not necessarily that everybody is inside when the curfew is imposed. There might be people who return subsequent 2 days or so after, so that they should have a clear understanding of how long the curfew will be for, or, you know, I'm just pulling time periods, and because I know there are restrictions on how long you can have a curfew. But I do believe that transparency and accountability on the part of the security forces, this sort of recommendation which comes from them, will strengthen the relationship between the citizen and the security forces. And it is for us to work out the best way in which we can achieve this. Those are my thoughts.
I tend to agree with you, Senator Scott Motley. I think anything that brings some certainty and some predictability in terms of how you conduct, or how the state conducts its affairs when these zones are declared, especially for things like curfews, is particularly important. I think what I'm hearing from members is that we're agreeing on the substance of the recommendation and the intention of the recommendation, but we could ask the technical team to get back to us with recommendations on the form it could take to achieve the intent.
Chairman.
Yes, sure.
Chairman, in respect to curfew, generally now, there's a view amongst the population which says, all they announcing a curfew is alerting the criminals. But usually the population is not aware that the curfew has been established. But there's a requirement for a notice to be made public so people can be aware of that. And so in the ZOSO, there ought to be that public announcement. It need not be prior to the start of the curfew. but certainly there's need for that. And we have to look at, in some of these communities, one road, people can leave from one road, even with the police there, up to the next road, or up to the school. So maybe in this ZOSO, we need to require that the notice be placed on a prominent place, be it light post, be it walls, within the community, so that there can be no doubt that the ZOSO has moved another step from just being ZOSO present to ZOSO Ultra, which is what the 72-hour curfew would be. So I hear you, and I'm not opposed to what you've said, but I just think
the very declaration of the zone, though, Senator Brown, at the very beginning, even when you go into the clear phase, the zone is declared and the public is made aware usually after the security forces have come in. So I think the general principle of declaring and you know, instituting security measures and then advising the public, I think, should be maintained. But I do agree that the advice of the public in full detail is important.
And bear in mind, Chair, the ZOSO could stand without clause 12, but we put clause 12 there to give these powers additional within the ZOSO. It is for that those reasons why I believe that people should be informed. It can't be that, oh, there's a ZOSO and therefore you can anticipate upward scaling of measures, security measures there. Because the ZOSO doesn't necessarily require that upward scaling takes place.
Agreed. Senator Golding Campbell.
Thank you, Chair. Just to say, I mean, I think what we are grappling with is the question of the mechanism of the notice to the community. And I'm not so sure, and I think you alluded to this, that we can really determine that right now. I mean, the fact of the matter is that no notice is likely to be 100% effective, i.e., there's likely to be people, you know, persons in the community who are not aware of the notice. So you put it on a post, some may see it, some may not. In this day and age, you know, a lot of our citizens operate, I understand we're a Twitter society. So the question of how do we deliver this notice and at what time, I think perhaps the technical team and maybe some feedback too from the security forces in terms of the communication within the ZOSO would assist the technical team in working out that mechanism. I think we're struggling with trying to determine what that is. I'm not sure we're going to do a great job at that.
I think you've nailed it, Senator Golding. I think we should, well, what I'm hearing from members, and I'm prepared to be corrected if I'm incorrect, is that we can agree to the intent, and we would ask the technical team to come back to us on recommendations for this space at a later date. With that, I'm going to move to the next recommendation, which would have come also from the JCF, which was related to the offense, to the creation of an offense of breaching the curfew. It's also recommended that the penalty of this offense should not be a fine not exceeding $1 million and the imprisonment or imprisonment for a term not exceeding 6 months. Firstly, I think let's look at the intent to criminalize the breach of curfew within the ZOSO. Can I take comments from colleagues? It would seem to me that this is consistent with other discussions that and other considerations certainly even under the DRMA.
Hello, good morning, Chair.
Member Jackson, how are you?
I'm good, thanks. I have no difficulty with the penalty for the breach because there must be some consequences for breaching a provision. But I think that $1 million is a bit excessive for the mere breach. If there is some other substantive breach emanating, that can attract a fine. But for the mere breach, I don't think it should exceed more than 500,000.
Yeah, noted. Member Jackson. Colleagues, any other recommendations or considerations? I agree that there has to be, I think, Member Jackson, I'm in agreement with you that there has to be consequence for breaching one of the provisions. The truth is 500,000 is likely to already be a mountain for anyone in a community that's declared as a ZOSO. That's just the unfortunate reality.
Well, Mr. Chairman, the penalty is not, it's not a mandatory penalty, it's a penalty up to. So presently under the Disaster Risk Management Act that speaks to breach of curfew, the penalty is $1 million. Persons are generally, based on what I've seen in the courts, not being fined in excess of 20,000 unless it is an egregious breach, where you have seen some fines go up to sums 150,000. I've seen publicized. So there are mitigatory factors that can arise. I like to see consistency between legislation. One speaks to safety, that is the Disaster Risk Management Act, health safety. One speaks to another type of safety. So if we are going to impose a fine, I would suggest that we maintain some, unless it can be explained to me, consistency between legislation across legislations that speaks to the same type of offense. You breach a curfew. And as I understand curfews and cordons, you can get permission from the officer on the ground in order to move about in a curfew. So it is where you have a situation where a person disregards that opportunity, because the curfew and the cordon is not absolute as I understand it. If you are in a situation where you need to move, you can get the permission of the relevant officer on the ground in order to get by the curfew or get by the cordon. But as I said, consistency across legislations for the same type of offense, I think that we should, if we are going to include it in the act, we maintain the consistency. That is my suggestion.
Before you come in, Senator Brown, I would make the point, looking at the context that the JCF had provided in their recommendation. If committee members see the severity of breaching the curfew in line as the JSF has submitted in line with obstructing an officer, then I think that's further support for the measure. You're coming in, Senator Brown?
Yeah, I note that the public defender also shared a view with us in respect to clause 12. Part of that view said no amendment to the law is necessary outside of the operations of under section 12 of the ZOSO. And she spoke about that JCF clause 30 of their act, for which the police also spoke here. Probably the SG could share with us what's the penalty under clause 30 of the JCF act. And well, the Constabulary Force Act, I don't believe that JD. So what's that? And do we really need this legislation, because you see, while Senator Sinclair it is up to, we have to recognize that it is the poor communities that are going to get ZOSOs. Not even the poor, the not so poor Central Kingston has gotten the ZOSO that they're asking for. But it's the very poor communities that are going to get this. And it's the poor people. And yes, somebody like Beaneman get 150,000. Senator Sinclair says, oh, some others may get 20,000. But unfortunately, some that is Mocha Fest don't get any at all. And it is that double standard that people are complaining about. And I think, Charlie, why are you shaking our head? So I think we have to have regard for the fact that it is the poorer set of people who this is going to affect. And to be talking about up to $1 million doesn't prevent a judge from saying 900,000 for you. That is two-faced there.
No, Senator Brown, I understand, but I was
shaking his head because if it's Senator Sinclair, they will charge him 1.5 million and above.
But you know, I don't look on the drafting of legislation in the way that Senator Brown has done it. And that's why when I made comment, there is an existing legislation that speaks to a breach of curfew and the penalty that applies, which is a Disaster Risk Management Act. And so if we were to, and that is seeking to protect the health of the nation, and this particular curfew that we're speaking of, where there is a situation that you would have to declare a zone of special operation that has a component that goes to safety, that goes to police investigation. If the police has, if there has to be a declaration of a curfew within a zone, it may be that the police needs to take a particular strict action in order to cauterize, find particular persons, etc. And if persons are willing to breach the curfew, meaning to say that they come out of their yard seeking to escape what is the dragnet of the curfew, then whether you are rich or whether you are poor, I don't see how that is going to cause me to have a separation in respect to how I draft a legislation that speaks to security. And security of communities is just as important as health security. I would also want to point out to you, Senator Brown, that the ZOSO legislation amended aspects of the Jamaica the Constabulary Force Act that increase the possible penalties for obstructing and assaulting a police officer, generally, not only within the zone. The penalties now, in fact, because of that, the offense is removed from the lay magistrates court, as it is now called. It was previously the petty sessions court, and places it into the parish court. So the penalty there is, I believe, increased. If you look on the schedule, and the SGs can confirm that the penalties for some breaches of the constabulary force were increased under the ZOSO legislation generally. And I believe the increase takes up to $1 million. So I'm not looking on going down the argument or the road that Senator Brown is going down about rich and poor. That is not how you draft legislation. I want to see consistency in our legislation.
Unfortunately, the society isn't consistent. The poor suffers the most, and the poor gets less justice. So I have a different philosophical view towards drafting legislation than you do. I agree on that. I am pro-poor and a defender of the people who suffers the most. That's the nature of my operation. However, if there has been an increase already in the fines, why do we need to further increase them?
No, but there is none in relation to the breach of the curfew. That is what I'm understanding.
Recommendation.
So the SG can guide us. And I think you had asked the most appropriate question, Senator Brown, when you made an inquiry as to what is the penalty, if there is a penalty, for the breach of the Constabulary Force Act, Section 30, or is it Section 30 or Section 50 that speaks to curfews under the Constabulary Force Act? I can't recall, but if the SG can give us some information as to answer your question, Senator Brown, as to any possible charge under the Constabulary Force Act and what the penalty would be for breach of curfew under that legislation.
I would make the point just in response to Senator Brown, that the very intent of the mass mobilization which comes from the declaration of ZOSO is indeed to strengthen and return the rights to citizens that live in these communities that have largely been captured by rampant criminality in many forms. So the legislation also shouldn't bring down the strength of the forces and what they intend to do to ensure that those rights are indeed returned to people.
Breach of the curfew, Chairman. Senator Sinclair explained how somebody could deliberately breach it, set out to do that. There are also innocent breaches. And again, I come back, such an offense may be a very strict liability. And somebody who have people needing to use bathroom in another property can understand a curfew where people are packed up in a shack and they want to come out into the yard for some space, some reading without any malintent, just to survive the slave-like cabin that they exist in. So it is those people I want to protect, not the one who willingly and trying to escape something. I'm talking about the innocent people who just need to survive, just need to breathe. And the curfew may very well be just a knee in their neck.
But Senator Brown, the curfew is not confining you to the house. It is confining you to your premises. So once you're not outside the premises into the public space, you won't be breaching the curfew. And
I've seen video of people in their premises.
Pardon me?
By members of the security. I've seen people in their premises being harassed by members of the security force.
Nobody should be harassed.
Nobody should be. But it happens.
And I agree that it does happen. But then
I'm going to take some guys on the technical team, but let me take comments from Senator Scott Motley and Senator Golden Campbell, and then I take comments from the technical team. Senator Scott Motley.
I thought, Chair, that we couldn't divorce this discussion from the one that we just had in terms of how do we convey to persons that a cordon and a curfew or a curfew has actually been imposed. We would have to resolve that, I think, before we could go on to make it an offense, because clearly everyone knows that ignorance of the law is no defense. So you couldn't tell somebody who accuses you of breaching a curfew that you didn't know one existed. And that is my concern. My concern is that if we're going to be just and fair, as I think legislators ought to be, then we have to balance everything. We certainly have to give the residents, the community, an opportunity to have that knowledge that the curfew or the cordon is in existence before we impose a significant fine for a breach. As I understand it, and the same thing with the DRMA, it is not a matter of, boy, I didn't know it was in place. I didn't know this was a law. I had no information. You have either breached the law or and it leads to certain consequences.
I think, Senator Scott Motley, we agreed that in principle, we would get that. So we would agree to we agreed in principle that it had to be known to citizens, and we were more getting into the form of how that would take, and we'd given the
right.
So what we're not. So I think we can, though we will defer and come back to that section. I think we can operate under the premise that we've agreed to the direction we're heading in that space and should proceed for consideration. Though we're waiting on specific language and what that form will take, I think we could proceed with accepting that is the route we're going. No? Or
I guess we could. I'm not really happy about the amount of the fine, and perhaps we should be guided by by the imposition of the fine for the obstruction of the constable in the execution of his duty, and determine whether the breach of the curfew or the cordon would reach that standard, and therefore the fine should be the same.
So I think what I'm hearing, let me take Senator Golding Campbell, and then I'll try my best to summarize.
Thank you, Chair. Just to make one or 2 points, because I think somewhat we're treading on the jurisdiction of the judiciary in this conversation. Because at the end of the day, someone who has breached the curfew and who is subject to a fine is going to be interrogated in the courts in relation to the circumstances. And certainly the circumstances surrounding the breach would be matters for the court to consider in relation to the level of fine that is imposed on that person. That's my first point. My second point is in relation to the purpose of the penalty. I mean, a penalty being imposed for something like this is intended, as I see it, to deter persons from breaching the curfew. And that deterrence is important, because without it, then how do we enforce the fact of the curfew? And it just seems to me that is something that we would consider, not in relation to whether or not a person can afford a particular fine or not afford a particular fine, because at the end of the day, if you don't want to be subject to a fine, then you don't breach the curfew. The circumstances in relation to someone who has a need to leave, to be on the road. Senator Brown spoke about going to a bathroom. I think I heard the opposition leader speaking about something related to that in the House recently. Those kinds of circumstances are circumstances that a person can put before the court and would be relevant, I think, to the arbiter in the court, the judge, who is going to determine whether or not this person should be subject to any fine at all, or what level of fine they should be subject to. So I don't think that, while I hear the concerns, and I think the concerns are legitimate concerns, I think that these are matters that have protections in another part of the system. And so I support us doing the investigation and the discussions with the technical team in relation to how that notice is given. But in terms of the level of fine, I'm comfortable with the proposal that is here, with the knowledge that our judicial system and the judiciary in particular will deal with the particular circumstances as they arise.
I just want to say and take a little bit of issue with how Senator Golding Campbell says it approaching court. There are some offenses where there is no inquiry. If you're parked in a no parking zone, one doesn't say why the judge is not going to inquire. Why did you park in a no parking zone? And when offenses like this a curfew is imposed, for example, and you don't have permission to be outside of the curfew zone, which you could have, every magistrate or every judge has a discretion as to how they would approach it. I don't think we should presume that all of them will approach it in that manner. What I do think is that we should get information about how it is treated under the Section 30 of the Constabulary Force. Okay, let me look at this now. So they say that Section 30 of the Constabulary Force Act, this, if you obstruct, it's $1 million or a term of imprisonment not exceeding 6 months. Do we hold this a breach of a curfew to that same level, Minister? Because I think that once we decide that it is at the same level, we can just move on from it.
Agreed, but let me take SG's point and then I'll ask CTD Richards if there's any policy objection to us moving forward as you have outlined. I tend to agree with you that once we agree that it is the same level offense and it should be the same level punishment. SG?
Thank you, Chair. So the Section 30 of the Constabulary Force Act, the amendment is not quite what is stated and on the screen. It's actually $1 million, and in default of payment of the fine, imprisonment for a term not exceeding 6 months. So that's different. It's really a fine, and only if you don't pay the fine, then you would have the custodial element. It's not fine or imprisonment. So that's a correction I wanted to make because it's an important distinction. In Section 50, Big B of the Constabulary Force Act, it is not an offense. There is no offense created if you breach the curfew, just for breaching the curfew. So I think this was something that the security forces wanted to address in the ZOSO Act. So it would be introducing a new element. But Senator Sinclair is correct. We do have that under the Disaster Risk Management Act. And under that act, the offense is $1 million or a term not exceeding 12 months. It is true that when we try to revise penalties from a law reform perspective, we usually try to achieve consistency across legislation. And I think it's obvious why we would try to, but sometimes there are nuances. There are times when we do vary from time to time, and it depends sometimes on the objective of the particular legislation. It could be that in one, you want to emphasize something more than something else. But the general concept is to try to achieve consistency where you have similar offenses across different pieces of legislation.
That admittedly creates an additional question, is whether we see the offense of breaching the curfew in a ZOSO in the same way, not only as the offense of obstructing an officer, but at the same level or as a lesser issue than breaching the curfew related to the DRMA. I would imagine that we would see them at least on par in terms of as it relates to the DRMA. My own personal position, I see the argument from the Constabulary Force, and I'm minded to agree with it that the breaching the curfew undermines the intent of that curfew, which is, to save lives and to allow the security forces to manage the space. I think, to my mind, it is the same level of offense as obstructing an officer. Is there any also position, Mr. Richards, from a policy, or what is there any considerations you'd like the committee to add?
Sir, Chairman, we actually had supported the JSF and the JDF with this proposal. So we have no issues as they have proposed.
The question before you come in, Senator Brown, and this comes back to the consistency point raised by Senator Sinclair and the explanation from the SG. Do we not see, or should it not then be consistent with if it's up to $1 million and 12 months, should it not, if you get what I'm saying, why I'm not sure I see any clear rationale why it shouldn't be consistent if we're targeting that principle of consistency. Senator Brown, and I take Senator Sinclair again. Senator Brown?
Yeah. One thing is clear, it is not an offense under the Jamaica Constabulary Force Act right now. Right. So we are trying to introduce into ZOSO a new offense, an offense which we say is under the DRMS. A piece of legislation that doesn't really get my full support because of how it's constructed. And I'm also hearing from my colleagues here that it's a matter for the court to decide. Then let's just be clear that this is not a strict liability and offense that we are creating. So for people deliberately breaching the curfew is what I'd like to introduce, so that it then gives an element of intent to be canvassed by the judiciary as against the strictness of you're outside and you're outside. The purpose for which you're outside is irrelevant in a strict liability sense. So let's introduce intent into it so that the judges can then take that into account if you're going there. But I'm not supportive of this offense being created here. And I have not seen it, after 3 years of, I've not seen the supporting data to say this is necessary. And this can just be another part of an oppressive approach to the poor in our society. So I'm not inclined to support it because it's not now in the JSC Act. And if it goes in by a majority, I would say, let it not be a strict liability offense. That is to say, let the judge have regard for intent. Was it deliberately done? Or was it just an accident, including a lack of knowledge?
I think the lack of knowledge part of or contextually how you've brought up lack of knowledge, I go back to my earlier comments in response to Senator Scott Motley, because I am proceeding certainly with my own analysis of the recommendations before us, that will be resolved because we've agreed as a committee that it needs to be resolved, and the specific language and the form in which that resolution will take.
I agree with that, but the issue is it going to be strict liability, or is it going to be one which mens rea is required?
Mr. Chairman.
Yes, Senator Sinclair.
I hear this discussion about strict liability and mens rea and so forth in relation to the curfew. And you have made the appropriate comment in relation to the previous clause that we discussed, and that needs to be made certain as to where a curfew exists and where a cordon exists. So I won't go into that because I accept your position that needs to be defined. And I believe Senator Scott Motley is also on the same page to say once we have established how citizens are going to be made aware of the existence of a curfew and a cordon, let us take a strict liability offense, which is exceeding the speed limit. Because I want Senator Brown, after we have established time and boundaries of curfew and cordon, and what is expected of an individual, and if the person breaches it, let us call it a strict liability offense because it exists. You did not get the relevant permission as is facilitated when you have curfew and cordons from the ground commander, and you have sought to and have committed a breach of the curfew and cordon. But let us relate it to the strict liability offense of driving in excess of the speed limit. If there was an emergency situation and one had to take one's family, say, to the hospital and you were speeding, because speeding is a strict liability offense. You are caught in a speed trap and you go to court. Yes, I'm guilty, Your Honor, because I did in fact exceed the speed limit. That's a matter of fact. But these are the circumstances. There was this emergency and I had to rush the person to the hospital. Here is documentary evidence that that occurred at that particular time. A judge can easily say, I've heard you, sir. You have committed an offense, which is a strict liability offense. So you are indeed guilty, but I will admonish and discharge you. I won't impose a fine on you because you are seeking to save the life of an individual. Let us take it into the curfew. Someone in the ZOSO under a curfew suffers a health situation whilst in their premises, and the person rushes out to take that person to the hospital. You may have breached a curfew. In fact, that is a fact, because you are seeking to go beyond. Outside your premises, you have gone outside the premises, you have also charged. These are the circumstances, Your Honor. I admonish and discharge you, sir, because you are seeking to save. What is the difference? In every situation that a person may be guilty because of a mens rea offense or a strict liability offense can be put before the court, and the court can determine what happens in those circumstances. That is the discretion of the court. I've seen it applied over and over again where persons have been admonished and discharged, no fine. I've seen situations where there is not even a fingerprint taken when there are fingerprint offenses. I'm not certain if this is a fingerprint offense, so it would not even form a part of the criminal record. But when we look on what it is that we are seeking to get from the first aspect of the ZOSO, which is a clear and to deal with high levels of criminality, where you need to have persons' movements restricted for the security forces to do their searches properly, and for persons to be able to identify whatever property may belong to them, etc., 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 which are security matters. I think it is something that once the boundaries are established, and if a person has no excuse whatsoever, that they did not seek, because a law-abiding person who may have to move to go to work would say to the gun commander, sir, I have to go to work at 5 o'clock. The gun commander says, fine. And person shows his work ID, his work schedule, and he's on his way. But we have to look on what it is the intent of this particular legislation, where a ZOSO is declared, it is because of high criminality. And you're going to say that if persons breach a curfew trying to escape the dragnet, no offense? I don't agree with it. I don't agree with it.
You know, I like how you put it. Like I'm saying that somebody trying to breach a curfew for bad purposes. No offense. That's not what I'm saying. That's the type of argument you're building. I am saying that the mitigation ought not just to be at sentencing, but the mitigation ought to come in as to whether the person is guilty or not of the offense. So a pregnant lady needs to go to the hospital to deliver a baby. You're saying guilty. No room for the judge to say, in the circumstances, I find you not guilty, and I don't have to admonish you. And I'm saying that there are circumstances in these communities where people with no bad intent, no malintent, are in breach. The judge must be given the chance to say, because it's not a strict liability offense that we're creating, that you're not guilty. But for you, Senator Sinclair, you seem to be saying guilty, guilty, guilty.
No.
And then we deal with the mitigation.
No,
so I can't see why you're not supportive of this being an offense which require
Okay.
intent.
Okay, so, well, I've heard you. But I suppose the discussion would even start before that, because the discussion would start from the security force, the ground commander. Agreed. But you are saying, and I want to oppose you, just want to have it saying without justification, and a person breaches a curfew.
Something to that effect. The language, the technical, the drafter can put in that allow for the mens rea.
But Senator Sinclair, putting in without justification, that then again leaves a huge opening, and it's open to subjective consideration.
But I suppose the police, you see?
Let's start from the intent of why we would declare an area as ZOSO. I think we understand that these would be areas that are immensely challenged with rampant criminality. That's one. We accept that as a recommendation in terms of the form, and that communication would be made, and that we'll come back to that, so that yes, people would be aware. We've dealt with the awareness space. I think we're at a point of agreement that certainly someone breaching the curfew, I'm not sure we're at agreement on intent, but certainly someone breaching curfew, there has to be consequences. What I'm hearing is a bit of a disagreement on what the consequences would be. But the point was made consistency within legislation, and to my mind, it is the breach of this curfew would be tantamount to the same concept, or tantamount to the same seriousness as or even more serious, because of the issues in communities declared as ZOSO. So it should be consistent with the DRMA. The other point that Senator Scott Motley had made, and what I'm hearing from my own policy team at the ministry, is that we saw it the same way as the JSF did, which is that it is indeed akin to obstructing an officer and should be viewed in the same manner. So we view it that way, certainly at MNS. As such, I would like colleagues' support to move in the direction suggested. I believe some tightening has to come under what the language would, or I'd be curious as to what the language would look like. And I think even, we should look at that. But I think I'm minded to proceed in that direction. The only objection I heard, our firm objection, was from Senator Brown intent, but I would like some guidance before you come in, Senator Brown, from the SG in terms of how intent can be considered from a legislative standpoint.
And Chairman, just maybe the SG could take this point into account.
Sure.
Is the obstruction of the police, as in Section 30 of the Constabulary Force Act, is that a strict liability, or does that involve mens rea? Just want that clarification, Chairman.
SG.
Yes, sorry, Chair. I was just trying to find
Sure.
The provision. I'll read it. If any person shall assault, obstruct, hinder, or resist, or use any threatening, abusive, etc. language, or aid or incite any other person to assault, obstruct, hinder, resist any constable in the execution of his duty, that offender is liable to, and it's a fine of $1 million or in default of payment. So when you say intent, you see there is always what would be proved. The element of the offense would be that there was the assault, the obstruction. The prosecutor wouldn't necessarily have to prove that you intended. So for instance, let me use another one, abusive language. It's just the fact of the use of the abusive language which would need to be proved. But to go back to the whole discussion of intent and the strict liability, Again, all of these offenses persons are charged, persons are prosecuted, but before that can happen, a discretion is exercised. If someone left an area and is returning home because they went to, say, the hospital, I really don't see why the police would then go ahead and charge that person for breaking curfew. I'm just making the point that every time we put an offense in a law, there's a discretion that's going to be exercised. The discretion first will be whether the person should even be charged with this offense. The prosecutor would also look to see whether this is an appropriate offense to take through the courts. So I'm just saying that should be borne in mind. And I know that there are issues with a number of matters that go before the courts, but my position has always been, and it's really because of the position I'm in terms of we put things in law, we can't always legislate thinking that it's going to go wrong or it's going to be misapplied in a manner in which we don't intend it to be. My perspective has always been we expect our judges to act in an appropriate way. If they don't, then there are other ways to deal with it. It doesn't mean that the legislation in and of itself is wrong. It just means that there are other issues that need to be addressed. I think that's what I have to say.
Senator Brown, I think that puts your concerns to rest.
No, not at all. But I'm not going to hold up the proceeding. I just don't agree with adding that when it can be dealt with otherwise. But don't let me hold you up. I put my views and I hold them strongly.
Sure. So
sorry, but Chair, I mean the committee can give consideration with the guidance of the CPC about language anyway, in terms of how you create this offense. I mean, with other offenses, we usually talk about knowingly, or, we put in certain other language in there to show there is some deliberate action taken. So I'm not saying knowingly is appropriate here, but I think there could be some sort of compromise in how the offense is crafted. And I don't know if CPC is always brilliant with these things, and she always has a lot of great ideas on these matters.
You're too kind, SG. I was thinking more about reasonable excuse as perhaps would be the appropriate language, just to make it clear that the offense wouldn't be a strict liability offense. But generally, it's presumed that offenses are not strict liability offenses unless it's specifically stated that, or as the SG alluded to before, just the way that of the nature of the offense, for example, using profane language might itself just leave no other option but for it to be strict liability.
So, Ms. Grant, can we, what I would like to do is I'd like with colleagues to approve it, but ask that you come back to us with language options, so that we tighten up exactly what the recommendation is from the committee. But the general direction, I'm sensing that persons do want it to be an offense. They don't want. We're supportive of giving the police some additional powers for those who would intend to breach the curfew for nefarious means or just intentionally, intentionally and knowingly, and that we would want the consistency along with and that we would support the consistency in terms of the punishment along with the DRMA.
Certainly, Chair, but I do agree with the observation that was made earlier that this question, in order to be properly settled, is really tied up with the whole settlement of the issue of the notice and how that mechanism would work. Because the offense, as I see it, would speak to the breach of the conditions as set out in the notice. So that would have to be settled for the language to be settled properly for the offense.
Okay, so I think what's best then, and to not hold the rest of the proceedings at ransom, is that we defer final position on this for next meeting, and we can look at how the notice is structured, which I think would give Senator Scott Motley some more comfort, and I believe would support, would subsequently then support Senator Sinclair's position. Is that fine with colleagues? And then we can move to the next recommendation.
And just a quick question, Mr. Chairman. Would if we end up at the point recommended by the Jamaica Constabulary, would that be a consequent, an amendment that impacts the Constabulary Force Act as was done in respect to the other amendments that affected the Constabulary Force Act, and not just limited to the ZOSO? So that would be for consideration.
I've been swayed by the SG and the CPC finding the appropriate language. But what Charlie is saying now to go, what Senator Sinclair is saying to extend this to the Jamaica Constabulary Force Act in a consequential amendment is not somewhere I want to go. And the review of the ZOSO is not a review of the JSC Act. And I'll be careful not to be importing what we do in a special zone for the country as a whole.
Sorry, Chair, if I may, just on this same point, the remit of the committee is really to review the Act, law reform, zones of special operations, special security and community development measures. The approach that has been taken in other similar types of joint select committees where they're reviewing an act is to make recommendations to the Parliament and to the relevant ministry to consider other amendments. So where you would think that there should be consequential amendments, what you do is make that recommendation in your report. That is one way of dealing with it.
And I was merely asking a question, Senator Brown, and just putting it on the table because it happened when we were doing the ZOSO legislation. It was done. So I was just asking a question. I was not coming to a decision because I knew that that would be something that is above my pay grade. It's a policy decision.
I'm happy we're on the same wavelength on that, Senator Sinclair.
Yes, Senator.
So, as discussed, colleagues, when we've settled the earlier issue in terms of how and what form the declaration takes and the terms and how it is published, we will revisit this recommendation and tie it up. But from a policy standpoint, we are heading in the direction of the JCF recommendation. There was another point made by the Office of the Public Defender as it relates to Section 12, and again, it's referenced Section 30 of the Constabulary Force Act. Admittedly, I'm SG, I'm not sure if you can help me out with this one. I'm not quite sure what their concern is. Our colleagues, I'm not sure what to make of this one, admittedly. They'd raised a particular concern in terms of...
Chair, essentially they're saying no amendment. And what I understand, and maybe would benefit from reading the public defenders comment out aloud. What I understand to be saying that they have provisions under the JCF Act now to act, but the army, the JDF would not, and they feel that argument is dubious, and they gave reason. So if we read aloud their comment, we will also be informed retroactively on the conversation we just had.
Right. Because we're going to revisit section 12 as per our recommit section 12 because of the form that the declaration will take. What I'd suggest is instead of detaining ourselves on further deliberation on section 12, let's resolve the issue, read the first point and that recommended amendment in relation to how the form that the declaration takes, that we recommit section 12 when that is brought back next week. Colleagues, fine with that, and we could, I'm assuming?
Fine with me.
So we would move to section 13. There were no recommendations for our comments made from the presentations that we received. Are there any points or any concerns that colleagues have before I move to section 14? Going once, going twice. Okay, moving to section 14. Search and seizure. Recommendation again from the Jamaica Constabulary Force for an amendment to section 14.3. It is therefore recommended in connection with search be removed from section 3.
I expect some Bigfoot kind of performances and some unicorn things. You see what I'm saying?
Then Mamila, your mic isn't muted. Thank you.
So, Chair, just to assist, it seems that the first rationale, what the JCF is proposing is a change. So the current provision says that the constable may seize, but the seizure must occur where it's in connection with a search. So you would have been searching and you may see something and that's when you would seize. The JCF is saying that you should be able to seize where it was not in connection with a search. So it's not that you went and did a search and then you seize. You should just be able to exercise the power of seizure. They think that linking seizure with a search is restricting their power and restricting the application of the provision. Seems that, in a nutshell, it seems that that's the proposal. They even say the power to seize in a zone should not be so limited. It should extend to seizure in any circumstance once the requirements that the seizure of the item will assist in preventing or controlling public disorder, or that the item is likely to be of substantial value to the investigation.
Chairman, what is the power of seizure now before ZOSO? Because ZOSO is giving them more power and says in the context of a search, they seem to be wanting more power generally. And so I'd like to know what is the seizure power that they have now, apart from ZOSO. I suspect reasonable suspicion may be part of what allowed them to seize people's property, people motor cars, people's fridge, people's TV. I mean, why do we want to give them more power that they don't have now when we already give them some? And the final point I want to make, where's the data after 3 years to tell us that they need this? We have been deprived as a committee reviewing this act of any data which says their work has been made more difficult because of the absence of this provision. We had 2 cases or 3 cases, and had we this provision, would have been able to do X, Y, Z. So it's just like a power grab to me that I'm not very comfortable with, because people property, you're not going to go uptown and seize people property just so. Let's protect those in the inner city communities.
I remind Senator Brown that, and certainly this is my own perspective, the need for a community to be declared a zone of special operations is on the basis of rampant criminality, gang war, significant loss of Jamaican life that would necessitate the police and the JDF needing to form a joint force to get to the point where they're able to rid a community of that criminal influence. It is, I think, impatient of debate that extraordinary circumstances, as we unfortunately we have in way too many communities in Jamaica, would require extraordinary actions. I'm open to hearing from colleagues. I don't think, certainly this is a debate that we have had in the Senate on many security related bills. I think that the fundamental need to protect communities and to protect the lives of citizens is the basis for the recommendation. No, I at a personal level, I support this space. I see Senator Scott Motley, Senator Sinclair, so you can comment. I'll take in that order, and then other colleagues who may wish to comment. Senator Scott.
I was momentarily distracted, Minister, but what I want to know is, what do they expect to attain from this clause? What is it that they find to be a challenge now, why they would want to change this? Because at the heart of it, we have to remember that we do have a Charter of Rights which guarantees certain protection to our citizenry. And if we are going to tamper with those rights, it must be justified, whether reasonably or demonstrably justified, in a free and democratic society. So I want to know, I just want to understand why it is that they would want to seize, but it not be in connection with a search. What are the circumstances which they have contemplated? Because if it has to be defended, that is how they have to defend it.
All right, so I've taken your comments, Senator Scott Motley. I'll revert as I have been doing after other colleagues have had a chance to comment. Senator Sinclair?
I am going to say that I am with Senator Brown and Senator Scott Motley on this particular one. And I'll tell you why. Section 14 is giving the Jamaica Constabulary Force the power to search any place, vehicle, or person within a zone without a warrant. The only limitation that they have is upon reasonable suspicion of an offense, that an offense is in the course of being committed, or has been committed, or is about to be committed. I don't know if they are wanting to read in any disjunctive way Section 14.3, because this power to seize any article would be in relation to that search that is referred to in 14.1, which they already now have increased powers to go and search your premises without a warrant in the zone. In other searches outside of the zone, they would have to get a warrant under various legislation that exists. And so I'm wondering if they think that 14.3 should be read disjunctive. So if, for example, if they are walking on the road and they saw somebody with whatever item it is, that they would be able to just seize it. I am not supporting that. I'm not supporting that. So I don't know if that is why they want to remove that it is being, the seizure is done in connection with a search. So not because you're in a zone that you should be given the authority to just see a person and just see something from them. Not, I couldn't agree with that. And I would not recommend, agree with them for the removal of the seizure being done in respect to that search, which they already have increased powers because of no warrant, but limitations because they have to have reasonable suspicion of an offense being committed, etc., 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 to effect the seizure that they are seeking. But to remove it, I believe that they may be wanting to read 14.3 as being disjunctive from 14, the other aspects of 14.
Senator Sinclair, would you then be supportive of the third recommendation as it relates to section 14 on in making an offense for preventing and attempting to prevent the search of a member? And I also asked, just as you're considering it, that Senator Sinclair and colleagues, the same recommendation comes under, which is under, it's the third recommendation from the JSC on search and seizure, and section 14 to be amended to making it an offense for preventing or attempting to prevent the search by a member. So I'd ask you to in that context. And one other point I wanted to consider, Senator Sinclair, because I'd like to hear your thoughts on it. Under section 15, there's a recommendation also from the JCF, which would be consistent with their initial recommendation, and as it relates to section 15.3, not to be jumping ahead, but to say, but this will, our deliberations on this will, I think, be applied to other recommendations which have come from the JSF, which is related to 15.3, which was a removal arising from a connection with a search be removed. So just pointing those out to you to see if.
All right, I'll have to look at what 15 actually says, but in respect to what you spoke about, the third recommendation,
right?
The third recommendation, if you were to go with them, isn't that creating a situation that already exists, that a person, if the police was effecting a search within the section 14, and somebody sought to prevent them from conducting that search, wouldn't that be obstructing the police, which is already an offense, which can attract a fine of $1 million? It's already there.
Agreed, Senator Sinclair. I was looking at that.
I think that I don't know what it is that they're asking for by that recommendation.
Yes, I support Senator Sinclair's observations.
I will have to look on 15 in a little more detail before I comment on 15. But those are
the only S that is missing. Shireen, Scott Martley, Sinclair, is Samuel.
And you know that the two S's, when we are in certain places, the two S's always agree.
And you know how Senator Golden Campbell by virtue of her first name. So the S's are agreeing, my friend.
So Senator Brown, you don't have an S in your name other than the senator?
Well, the senator is not part of the name. But there's no S in any of the three names. There are no S's there. No S there.
All right, Senator Brown.
What I am is supportive of democracy, and my sense is that colleagues on both sides of the aisle are particularly uncomfortable with the recommendations made. Certainly the first one in relation to search and seizure as it's related to 14.3. So I think what the committee is saying is that you would not be minded to accept that recommendation.
Want to say, Chair?
So Member Miller, you coming in?
Yeah, man, I'd like to place my
All right, so I think that seems to be the common position of committee members. So I will go with well, I don't have a choice. I will go with the view of the majority. So it is not the position of the committee or that recommendation be accepted, which brings me to it was the second recommendation, rather, Senator Sinclair. And I've taken your point on the obstruction, that this would already be dealt with as an offense as obstruction of a council. SG, is that also your position in looking that this is already dealt with?
Sorry, Chair. They're asking for words to be inserted in 14.4a. So right now, 14.4a speaks about that the constable cannot seize any tool of a lawful trade or business unless the constable has reasonable grounds to believe that the tool was used or is being used. And the suggestion is to also include or is likely to be used in the commission of an offense.
I think SG, the comments was not that the chairman was seeking, was about those arguments before, not 14.4 yet.
Oh, sorry. Sorry.
I don't know. The chairman could confirm. Sorry.
Oh, sorry, Chair. I thought you had moved on to what was on the screen now. I
had SG, but I was saying in the context of the previous debate.
Oh, so this is a little different in terms of the amendment to 14.4a. I know what you're dealing with was the other recommendation afterwards, but the one on the screen right now, it's to provide another situation in which the constable could seize a tool of a lawful trade, and that is where it is likely to be used in the commission of an offense. They would like that to be included as a ground to be able to seize a tool of a lawful trade or business.
Let me hear from.
I have to tell you, it's going to be difficult to determine. Sorry, let me stop.
Go ahead, SG.
I don't think based on the previous debate that this is something that.
But the problem is, you could have a gardener who walks with his lawful tool for his trade, and because of what that tool is, just because he has it with him, an argument could then be said, oh, it's likely to be used in the commission of an offense, when he's really just a gardener with his lawful tool trying to leave home to go to work to conduct his trade. So the whole issue with it likely to be used could expand it to a way that could create a problem from my perspective. And in fact, that was one of the reasons it was not included in the first place. But I'd said I would stop because it could be that there are arguments to support it. I think part of the problem we have is that we don't have the supporting or the rationale for some of these proposals. So it makes it hard to be swayed, because remember now, these are matters that touch and concern the Constitution. And for members of the committee to go along with these sort of proposals, you really would have to have a really good rationale. If these matters did not touch and concern Chapter 3 of the Constitution, I could understand them just making the proposal, but you really need a good basis on when you're going to now consider whether there could be a likely infringement of a right or a freedom.
And I take note also on this one, the comments of the public defender. So I don't, barring submission of particular context and new arguments, I think the sense I'm getting from the committee is that this is also not one that we would support the accepting of that recommendation. The next one is the offense for preventing or attempting to prevent a search by a member of the joint force. I believe that's the one that Senator Sinclair and me were going back and forth. Well, we're discussing what could be. Is that already not covered under the obstruction of the police? SG.
Yes, Chair, and even Senator Golden Campbell also had accepted the point. It is obstruction, and that is already an offense under the Constabulary Force Act. And
that, as I recall, was
with an increased penalty of $1 million or in default of payment, custodial sentence, maximum of 6 months.
Okay, so we wouldn't need to accept that because that power already exists for the police. Senator Brown, are you trying to come in?
No, not at all, not at all.
Sure. Any objection, colleagues, or can I move on to the section 15? We've not accepted those recommendations.
Chair, just to be clear, none of the recommendations for section 14 sign paper with us, yes?
Correct. That was certainly the position that I took from colleagues on the varying matters. Okay. Section 15, it is proposed that the words arising from or in connection with a search be removed from 15.3. So I'm trying to look at the principle or the original act.
I think that is just trying to make the connection to what they're proposed in respect to 14, Mr. Chairman. That's why they're asking for it to. So I think it would remain.
It would remain.
Because it remains
in 14. Predicated on or accepting the removal in all the previous.
Right.
Okay, so we wouldn't accept this recommendation.
No.
Moving on to the next recommendation, custody or disposal of things seized. It's recommended that there is an amendment of section 15.3 to include with an item which was seized to prevent or control. Well, this would also be in relation, this would be, I think, bringing consistency to their earlier recommendation. So I don't think we could accept this one either. Correct?
That is correct.
All right, so.
Take all the man things, get back to you.
That's not the intention of, just for the record, Senator Brown, that's not the intention of the force, but I accepted the recommendations earlier.
So what this says now at 15.3, you know, that we agree to, yes, is that if you take away the man thing, I have no use to it in terms of evidence and support, get back to the man. And I've seen too many cases where people vehicle have been taken away and them have to sue and wait years before them get back in vehicle, and God knows what happened to it when it's at the police station. Or wherever it is kept, whichever pound it is kept.
As we said, we're not accepting the recommendation. So, yes, Senator Scott Manley.
I'm sorry, Chair. I was just pausing a little because what I'm seeing on the screen is that they are saying that where the item was seized to prevent or control public disorder, there should be a specific clause or specific insertion to say that it should also be returned at a particular time. That is what I'm seeing on the screen, so that in the same way that where it is that it is no longer of evidential value in any criminal proceedings arising from or in connection with a search, then he shall cause it to be returned. They're asking that it be clearly stated that where it was seized in circumstances where it was done to prevent or control public disorder, that there should also be circumstances under which it could be returned. Well, am I correct in my interpretation,
yes,
please, Counsel?
Yes, Senator, and I was going to actually take the committee to Section 14.3 of the Act, where it says that the constable may, in connection with a search, seize any article that will assist in preventing or controlling public disorder or is likely to be of substantial value. So it was
Yes.
there were two limbs in 14.3 when you were going to seize, but when you got to 15.3 in terms of return, it only spoke of one limb, which was that is no longer of evidential value. But the other reason for seizing, which is to prevent or control public disorder, was not specifically mentioned in 15.3. So I do take the point that there is an inconsistency there.
Yes. That is what why I asked that we pause and not go past it, because I do also support the fact that it ought to be addressed.
I agree with the points made by the SG and by Senator Scott Motley, Mr. Chairman, in respect to closing that lacuna that exists by the non-exclude that by the fact that you don't have included in 15.3 the words that would have been relied upon to effect the seizure stated in 14.3. So the 15.3 has to be amended to cover that gap that presently exists.
So you'll be accepting the recommendation?
Yes.
For the wording to be included.
Yes.
Yeah.
Okay.
And if you do that, then just like arrests and matters like that, the JP should be brought in, because there can be unreasonable denial under the argument of it may contribute to further disorder of somebody's property. And just as in the issue of an arrest, the JP can be brought in, the JP should be brought in assisting in resolving any dispute here as to whether or not disorder is likely to flow from it. So there should be some protection for the citizen if we put that there.
Well, I don't think that is where it would actually come in, Senator Brown. And I was actually thinking of that particular situation when we were still looking at 14, section 14. Because if an item is seized and the officer does not come to the conclusion that is set out in 15.3, I think that for the protection of the citizen, and because of the fact that 14.3 speaks to what is, we would have to determine what is actual public disorder, controlling public disorder, or is likely, because that is a term that we were not too satisfied with when we were looking at 14.4a. It has a lot of discretion in it. So if an item is seized by an officer and he does not come to the position that he should return it, in the interim, what does a citizen do? And I believe, as Senator Brown has said, that we should put in a provision that allows for the citizen to go before a JP, Justice of the Peace, and I believe that under the ZOSO legislation, the Justice of the Peace are certain specific Justice of the Peace with a certain level of training. I think we discussed that on the last occasion, to adjudicate whether the item should remain seized or not seized, and not just allow it to be left to the decision of the officer under 15.3. What I'm saying would possibly require some amendment either in 14 or somewhere in 15 to include another clause, and I would leave the wording of that to the persons who are so well trained in effecting wording to legislation, Mr. Chairman.
Comments noted. Senator Sinclair, Scott Motley, and Senator Brown. Are there any additional comments to be made in relation to this section?
Chair, can I make a comment which is not at all related? I have a problem and I have to leave now. I deeply regret it because I know how important it is, but I'm going to ask to be excused.
Okay. Well, we will certainly miss you, Senator Scott Motley, and thank you for your interventions. I'm going to ask just for a pause for 2 minutes. I think it could be useful just for colleagues to get 2 minutes and then we restart. Thank you.
Thank you, Chair. Thank you.
Just a pause for 2 minutes.
We work to make communities safer by essentially looking at the structures in the community that contribute greatest to social capital building. Try to reinforce, build, and establish those structures in a way that the community can sustain their own safety and own their own peace. When we say, for instance, we're doing a zinc fence removal program, what we're really doing is improving the line of sight. If you're on the street